All right, well, welcome everybody. My name is Lanya Saperstein. I'm a member of the CGCC's Legal Counsel Committee, a partner at Jones Day and an adjunct professor at Fordham Law School. I have the pleasure of moderating today's panel. I'm glad to see some old friends amongst the attendees as well as some new friends. This is part of the CGCC's Legal and Policy series, and we thank the CGCC for this opportunity and being just impressed by the amount of quality content the organization has been able to provide during lockdown. I'm sure everyone knows this, but to the extent you don't, the CGCC is the largest and most impactful independent non-profit organization representing Chinese companies in the US. It is committed to facilitating cooperation, building trust, and representing the interests of its Chinese and American members as they seek to expand their business operations and investments here and across borders. The Legal and Policy Series events are produced jointly with leading law firms, and I would agree with that, to provide expert insights throughout the year on legal issues that matter the most to the US-China community. And we'll cover a couple of preliminaries if we can. Next slide, please, Helen. So 3 preliminary points. We're recording today's webinar. And we'll make the recording available afterwards along with the PowerPoint slides. If for any reason you can't access them, do let me know and I'll be happy to send both the recording and the slides to you. Second, our disclaimer. The views expressed on today's panel are our own and do not necessarily reflect the views of the CGCC, Jones Day, or any of our members or clients. And the program today is not intended to create an attorney-client relationship, but we do certainly hope that you find it helpful. And finally, please feel free to ask any questions you might have during the webinar. There's a Q&A tab, and we already actually received a few questions that we will get to at the end. Okay. To what we're covering today. We're here to discuss the long reach of US courts over Chinese companies. And I've been practicing for now almost 25 years. And the one issue that non-US clients, and not just Chinese clients, but all foreign clients, have consistently expressed bewilderment over is the reach of US courts over non-US parties, often reaching well across international borders. The term long-arm jurisdiction can cause lawyers and business people alike to shudder. Now, in recent years, courts in the US, led by the US Supreme Court, have started to pull back that reach. But there are good lawyers on the other side who come up with new and clever legal arguments and attempt to expand the scope of the reach of US courts. Today, we'll discuss the fundamentals of personal jurisdiction, several important new developments in the area, and potential defenses that Chinese companies can raise. We will also discuss a recently enacted provision under the AML Act that came into effect in January of this year that expands the power of the US Department of Justice to reach into foreign banks and get documents located anywhere in the world. Throughout the webinar, we'll be emphasizing the practical aspects of these legal issues. You know, as a business person, you may be sitting there saying, I don't need to worry about the ins and outs of these esoteric constitutional issues. But you do know that US litigation can be expensive, time-consuming, and perhaps most importantly, distract from your core mission of expanding your business. there are jurisdictional defenses that your companies can raise at the outset of a litigation, and you should be mindful and aware of them because they're an effective tool in response to potential lawsuits. So let's turn to our panelists, and I will introduce them, go over our agenda, and then we can dive in. There I am, pre-COVID without my beard. Next slide, please. All right. Brian Lee is a partner at Jones Day, a former law clerk to Justice Clarence Thomas on the U.S. Supreme Court, and a nationally renowned appellate lawyer, and he knows the area of personal jurisdiction very well. Next, Rajiv Matrija, and I'm sure I butchered your name, last name, I apologize. He's a partner as well at Jones Day, a former law clerk to Judge Walker on the Second Circuit. He worked on the Jones Day team that represented Goodyear Tire in the seminal U.S. Supreme Court case, Goodyear Tire versus Brown. And we'll be touching upon that case as well as the cases that followed it. Finally, we have, Brian Rabbit is recently joined us from the Department of Justice, where he was a senior official. And while he was at the Department of Justice, he prosecuted hundreds of cases. He too is a former appellate clerk. So we really have some real firepower in terms of appellate advocacy here on the panel. And then Helen Jiang is an associate at Jones Day. She is a graduate of Harvard Law School, received her JD and JM from Peking University. And as those who've attended the elite China colleges, you know all too well how hard they are to get into, almost as hard as getting a Supreme Court clerkship. So with those introductions, let's turn to the agenda. First thing we'll discuss, Brian Rabbit and I will discuss why personal jurisdiction matters. We want to make this a practical session for the attendees. Second, Brian Lee will offer a quick jurisdictional primer, just so we're all on the same page. He will concisely condense an awful lot of case law and history into a few minutes. Then Rajiv will touch upon consent jurisdiction, and that is one of the hot legal topics right now in the area of personal jurisdiction that's actively being litigated in a number of states, and including in New York, in the IBAR litigation, which we actually have a role. Then Brian Lee will cover specific, or what is known as long arm jurisdiction. And there's a recent Supreme Court decision that came down and that he will discuss. Then Brian Rabbit will discuss the DOJ's expanded powers under what is 6308, Section 6308 under the Anti-Money Laundering Act of 2020 that came into effect on January 1st or 2nd of this year. And then we'll have a quick discussion about jurisdiction and correspondent banking, which flows out of 6308, and that will be handled by Helen. And then finally, we'll end with a Q&A session. Again, I think April just sent out a chat. If you have any questions about the stuff we're covering, we're going too fast, going too slow, do let us know. So why does it matter? I would say it matters for at least three reasons, right? From a legal point of view, a party needs to raise and preserve its jurisdictional defenses at the outset of the case. So you need to show up and you need to raise the defenses. If you do neither show up, or if you show up and don't raise the defenses, you waive them. And that leads to the second point. Second point is tactically, right? If a party raises and wins a jurisdictional defense, it can terminate the case at the outset, avoiding time-consuming and distracting discovery, extensive motion practice. So as a tactical standpoint, jurisdiction is not only a pressing constitutional issue, but an effective defense if applicable. And third, it's worth a defendant's time to raise these jurisdictional defenses at the outset of the case. You know, while we couldn't find any stats on the success of jurisdictional motions, we did find a study that found that 60% of claims were dismissed at the motion to dismiss phase. In other words, at the first sort of procedural chance you have to raise these and other types of defenses. So, more often than not, if you file a motion, you have a good shot of dismissing the claims, thereby avoiding all the expense and burden of litigation. So, as a practical matter, it matters. As a legal matter, it matters. And just as a constitutional issue, it's certainly important. So, talking of the Constitution. And actually, sorry, before I jump there, the DOJ. The DOJ has expanded powers under the AML Act. And while it's a little bit different from the concept of personal jurisdiction, it's not worlds away. And one of the defenses you could raise in response to a DOJ subpoena is a personal jurisdiction defense as well as other defenses. So as a practical matter, jurisdiction matters. Okay, now talking of Constitution, let me hand it over to Brian Lee.
Thank you so much. And I just want to thank CGCC for having us reiterate Lanier's thanks. So we've got a good sense of why jurisdiction is important. And now we can talk a little bit about how it works. Still practical because this is going to affect the way these sorts of defenses are framed in court, but unavoidably legalistic a little bit. But I want to be clear at the outset, jurisdiction is about power. That's just the law word we use when we're saying power. And it's a high stakes endeavor for all the reasons that Lanier gave. And you should bear this in mind. If a court has jurisdiction, even if it gets the law wrong, you can be punished for failing to obey it. On the other hand, if the court lacks jurisdiction, but gets the law right, you can still escape its actions in what's called a collateral attack. So it really is the core of the court's power, which is why it's so potent. The first thing to bear in mind is that there's two types of jurisdiction. There is what's called subject matter jurisdiction, and then what we're going to focus on is personal jurisdiction. Just so you have context, subject matter jurisdiction is the court's power over the type of claim. So some states have dedicated business courts. Georgia has one that's nascent, but like North Carolina has one. And so maybe they have power just over all the business cases in the state above a certain value. Or if you know that federal courts are different from state courts, if you have patents, those cases have to be heard in federal court. So that's about subject matter jurisdiction, is this kind of claim within the court's power. Even if that is met, though, the court has to have power over the litigants, the people it's going to bind. And so that's the personal jurisdiction concept over you, so that it can make you pay money or do what it orders you to do. Next slide, please. A little bit about background. In the old days, that power concept was literal. They would send out the police and they would arrest you if you didn't show up. And that's how they got personal jurisdiction over you, as they had possession of your body. Or if you're an entity, they would seize your property and then would be able to adjudicate whatever they wanted up to the value of that property. As corporations became interstate and then still later international, the Supreme Court decided, well, that doesn't seem very fair. It doesn't seem fair that an international conglomerate might have some of its property seized by a state that has no interest in the dispute, and then that state can do whatever it wants. And that's really dangerous because states vary in their policies. I'll give you an example. California is very much stringent environmental laws, which means if they acquire jurisdiction, they oftentimes, more often than not, choose to apply their own law. And so the court was concerned about states basically meddling in things that just weren't their business. And so personal jurisdiction limits were one way of accomplishing that. And so the Supreme Court in 1945 says, we've got a new test. We're not going to let property be seized. We're not going to let people be arrested and hauled into court typically. Instead, we're going to say, if the defendant has sufficient minimum contacts with the state, then the state can adjudicate the dispute if it's fair to do so. In cases that followed, that gave rise to two different concepts. And I realize there's a lot of labels here, but that's how the courts treat it. One is general jurisdiction, That is all-purpose jurisdiction. If you are subject to general jurisdiction in a state or in the U.S., you are subject to jurisdiction there for any and all claims that you are subject to without regard to whether the events happened somewhere else. And then there's specific jurisdiction, which is claim tied, which means the jurisdiction exists maybe for one claim, but if another claim happens somewhere else, say in New York, and you're talking about a California court, California, within limits we're going to talk about later, can't adjudicate that dispute. So those are the two basic concepts. First, it makes sense to talk a little bit about general jurisdiction because that's really going to set the table for what the court's been up to lately. I mentioned a moment ago, International Shoe, that important case was decided in 1945. And all it said about general jurisdiction was sometimes if a defendant, a corporation, an entity has enough contacts with a forum, we're going to let that forum state adjudicate any claim at all. Now, the court didn't define what it meant. So what often happens here is that lower courts, kind of left to their own devices, got very aggressive. And they started saying things like, well, if this defendant sells a lot of product in our state, we're going to let them be sued on anything here because they're selling a lot of product. And that meant you could have human rights suits, environmental suits being held in aggressive fora just because products were being sold there. The Supreme Court thankfully stepped in and put a stop to that in 2014. They had been building this for a while. So I know Rajiv was involved in the Goodyear case. That was a precursor to a case called Daimler, where the court really drew a line in the sand. And they said, basically, general jurisdiction exists only where the defendant is essentially at home. For individuals, that's easy. We're talking about domicile. We're talking about the state or the place of citizenship. It's much more difficult for things like artificial entities. And so what happened in Daimler is a great example. It's a German company, but the lawsuit was brought in California, one of those historically aggressive jurisdictions. And the lawsuit was brought by Argentinian plaintiffs saying that Daimler had participated in human rights abuses in Argentina and that it could be satisfied because Daimler had a subsidiary that had a couple of plants in California and because Daimler sold a lot of cars in California. So that's an extreme exercise of state power. And so the Supreme Court stepped in and said, no, essentially at home has to mean essentially at home. And so really we're only looking at the state of incorporation, wherever the organization gets its legal power, and the principal place of business. Plaintiffs immediately started trying to get around that rule. They started trying first to say, well, Daimler was just about a certain kind of case. It was about a certain type of defendant. In two cases, the U.S. has basically said, no, Daimler is an all-purpose rule. One is called Gucci, where the Second Circuit held that New York couldn't exercise general jurisdiction over the Bank of China just because the Bank of China had some branches. So it's not about the type of defendant. It applies to all defendants. And then in a case called BNSF, they said that it's not about the type of claim either, because that was a railroad worker compensation case. And the court said, no, Daimler governs general jurisdiction in all contexts, which brings me to this slide, which is that plaintiffs realize that now general jurisdiction is going to be tough. For a foreign company, it's often going to be non-existent, absent something really extreme. And so now they have developed some workarounds they're trying. One is to expand the concept of claim-specific jurisdiction, which I'll return to in a little bit. And the other is the idea of leveraging consent in the state to jurisdiction, basically forced consent. And I know that Lanier and Rajiv may have some thoughts about that.
So let me hand it over. So that's the background of jurisdiction. So in other words, there was a good move in the on the general jurisdiction front, and really Daimler really in a way changed the landscape, and then obviously Gucci came along and clarified it. But plaintiffs, lawyers are wily, right? And so they are looking for ways around general jurisdiction. It used to be that if you had a branch, a single branch in New York, you were subject to worldwide jurisdiction. In other words, any event that happened anywhere in the world, you could be sued in New York for it, so long as, let's say, a bank had a branch, or a company had operations in New York. That law has changed. However, the plaintiffs now are looking for workarounds. And one of them is the concept of consent, and we'll get to that next, as well as expanding specific or long-arm jurisdiction. So let me hand it over to Rajiv to talk about consent.
Thanks, Lanier, and thanks to the CGCC for having us. It's a pleasure and a privilege to speak to you all, even if only virtually. So consent jurisdiction, what is it? So as Brian was noting at the outset, personal jurisdiction is all about power. What is the state's authority over the defendant? And elaborate doctrines have evolved over how to establish that through the defendant's contacts with the state. But through it all, going back to the very beginning of principles of personal jurisdiction, consent is always a basis for establishing jurisdiction. If a defendant consents to a court's authority, then it's appropriate for that court to exercise jurisdiction over the defendant for purposes of that lawsuit. The most classic example of that would be a contract provision, where frequently you will have contracts, and some of you all may be quite familiar with this in your own contracts, where the contract specifies that any lawsuits shall be brought in a particular forum, and that the parties to the contract consent to jurisdiction in that forum. But another species of consent, and one that plaintiffs have long argued for, and that has become a particular area of focus in recent years in light of the case law that Brian mentioned, is to argue that when a defendant or when a company has registered to do business in a state, that functions as consent to general jurisdiction in that state. So by registering to do business in a state, you, the argument goes, have consented to jurisdiction in that state's courts over any and all types of litigation. It's general jurisdiction. Registering to do business is no different than incorporating there or having a principal place of business there, or so the argument goes. What is far from clear, however, is whether that argument still works under the Supreme Court's most recent cases talking about the strict limits on general jurisdiction. So if we could go to the next slide, please. This is an issue that's right now being actively litigated across the country. In the New York Court of Appeals, there's a case right now that Lanier mentioned called IBAR versus IBAR, where we at Jones Day actually have a role in an amicus brief that's been filed. It's an appeal of a decision from the Second Department of New York's Appellates Division. And the Pennsylvania Supreme Court has another pending appeal that is currently considering whether general jurisdiction can be based on registration to do business in that state. And these two courts, these two cases are far from the only cases to have touched on the topic in recent years. As this slide shows of litigation, lots of decisions weighing in on this question and on both sides of the issue. So on the left side here, you'll see that post-Daimler, many courts have held that registration to do business in a state does not consent to doing business, does not consent to general jurisdiction in that state. Courts in Delaware, Illinois, Missouri, Nebraska, Oregon, and Wisconsin have all held that in the last few years. And on the flip side, courts as listed here in New Mexico, Iowa, and Minnesota have all held that registration to do business does consent to general jurisdiction in that state. And these lists are far from exclusive. There are more courts on both sides of the aisle on this question, holding that registration either does or does not consent to general jurisdiction. What's the story with IBAR, the case in New York? I think this is a helpful illustration of how this principle works and what courts have said about it. It's particularly relevant to a lot of corporations because it involves New York law, where quite often companies are doing business and have registered to do business. So IBAR is a personal injury case. The plaintiffs brought an action concerning a car accident that occurred in Virginia, and they sought to recover damages from Ford and Goodyear, the car manufacturer and the tire manufacturer, for injuries they suffered and for wrongful death. There's no general jurisdiction under either over either Ford or Goodyear under the precedents and principles that Brian was talking about. Ford's incorporated in Delaware and with its principal place of business in Michigan. So general jurisdiction would exist in those two states, Delaware and Michigan, but not in New York. And Goodyear is subject to general jurisdiction in Ohio, which is where it's incorporated and where it has its principal place of business. And the accident occurred in Virginia, which would suggest the possibility, perhaps specific jurisdiction, which we'll get into later in Virginia, but not New York. So what the plaintiffs argued is that the New York courts had general jurisdiction over Ford and Goodyear because those two companies happened to be registered to do business in New York. Even though the lawsuit doesn't arise out of those companies' contacts with New York, doesn't concern what those companies were actually doing in New York, by virtue of the fact that they registered there, the plaintiffs argued that equals consent to jurisdiction and the case can proceed. However, the Second Department of New York's Appellate Division rejected that theory. And what the court said is that under the Supreme Court's most recent cases on general jurisdiction, most recently the Daimler case, which was very clear about the limited circumstances in which general jurisdiction exists, it's too much of a stretch to say that merely registering to do business amounts to consenting to general jurisdiction. And I think it's critical to note here that what we're dealing with are statutes that require merely registration to do business and the appointment of an agent for the service of process, but no statutes or registration requirements where someone is explicitly stating that they consent to the jurisdiction of the courts. It's not as if the New York statute or the New York registration process, for example, had some form where you say, I hereby consent to be sued in New York over anything and everything. Instead, the registration is not explicitly connected to that. And what the court held in IBAR and what other courts have held in connection with similar statutes is you can't turn that into a consent over general jurisdiction without violating the US Constitution's due process clause. Now, that was a decision of the Second Department, which is not the highest court in New York. The New York Court of Appeals is New York's highest court and is hearing that case now. They'll be hearing the case this fall. So stay tuned for what the court will do in IBAR. It's sure to be a closely watched case and an important decision. Whatever happens in IBAR, however, as I mentioned earlier, there is a split in authority over whether this theory is permissible. And if that split persists, if we could go to slide 17, please. If that split persists, it's likely that the US Supreme Court is going to address the question. Already, some justices on the court have shown that they're attuned to this question and the validity of this theory. Justice Gorsuch, for example, in the Ford case that Brian will be talking about shortly, in a concurrence, noted that the validity of this theory is far from settled in light of the Supreme Court's most recent rulings on general jurisdiction. And when you have disagreement over such a fundamental question of state power, those tend to be the sorts of questions that the US Supreme Court will get involved with in order to set a uniform standard for all of the states. So stay tuned for more on that as well. Now, even if the theory is permissible, though, I think one important point to keep in mind is that it supplies jurisdiction only over the entity that registers to do business in a state. And corporate separateness can be very helpful there. If a subsidiary of yours has registered to do business in the state, even if this theory of consent by registration works, it supplies jurisdiction only over the subsidiary that registered. It should not subject the parent company or any affiliates of the subsidiary to jurisdiction in that state. And so that can be a very helpful defense if you've got a subsidiary in a particular state, but the lawsuit is brought against someone other than the subsidiary. Now, there is an exception to that rule for corporate alter egos. Basically, this is an exception that applies whenever you have circumstances that would allow you to pierce the corporate veil more generally, where companies are ignoring corporate formalities and there would be some sort of injustice that would result from respecting the corporate formalities. It's a very high bar. but it is one that plaintiffs will often try, and I think we can expect to see with some increasing frequency as the basic ground rules of jurisdiction tighten up more. So that's consent jurisdiction in a nutshell. And I think in the coming months and years, we're going to see a lot more litigation activity in this area.
Thank you, Reggie. It's very helpful. And just this is why I think it matters particularly to the attendees on this call. I'm sure a number of the companies are registered to do business in New York, and they've registered with the Secretary of State in New York because that's a requirement, right? And so it seems like a bit of a gotcha moment if there's a statute that says, okay, well, you need to register to have the agent accept service, and then say, well, by the way, you now consented to general all-purpose jurisdiction. So it's relevant if your company has registered to do business with the Secretary of State. It's also, I see a number of banks on the line as well. It's relevant to banks because the banks have a similar requirement under the New York banking law, which is you appoint the superintendent of the DFS as your agent to accept service. And so while the IBAR case doesn't deal directly with the banking law, it's the corporations law, you could see how it's not a stretch for a litigant to say, well, any decision in IBAR is very relevant to the banks and any bank that has appointed an agent for service. So it's a real issue. It's one that's been actively litigated, and it's one that you want to sort of stay attuned to because it's going to be important. And if it goes the right way, and we hope it does, we have an amicus position in it, then it could be very helpful. So, but that's not the end of the story because, again, as we said at the outset, the plaintiffs are wily and they are also relying on specific jurisdiction, which is known as long-arm jurisdiction, one and the same. And so let me hand it over to Brian Lee, who can fill you in and explain specific jurisdiction, the recent decision issued by the U.S. Supreme Court.
Thank you very much. Exactly. Specific jurisdiction is long-arm jurisdiction. And the reason it's called that is because a state, it doesn't have general jurisdiction over you. It can't, you're not effectively a citizen, but it is extending its power outside of its own borders to hold you, the defendant, to account in its courts for things that are supposed to be related to your contacts with the state. As general jurisdiction has tightened, this is another area that plaintiffs have pushed on in an effort to kind of make up lost ground. There's three main components, and it's useful to understand them, even though only two of them have had movement in recent years. The first is the requirement of purposeful availment. That's another lawyer word like jurisdiction that doesn't really capture what's going on. It just is aimed at fairness. Did this defendant try to do stuff in this state, or did fortuitous circumstances kind of inadvertently connect this defendant to the state in some way? And the reason that's deemed fair is because the very basic conception of specific personal jurisdiction or long-arm jurisdiction is that this defendant has done something to subject itself to the authority of the state through its actions. Otherwise, we think it's kind of state adjudicate their rights. I'll give you a fairly extreme example. Say a small local business owner in New York, he makes handcrafts, he sells them at a market, 3 or 4 secondhand sales, he only sells them in New York, 3 or 4 secondhand sales down the line, somebody in Oregon, hurts themselves on the handcraft. We're probably going to say, it's always dangerous to weigh on hypothetical cases, but a court's probably going to say, well, this local artisan in New York didn't invoke California or Oregon. He wasn't trying to do anything there. And so we're not going to let California or Oregon adjudicate his rights in those circumstances. That's the basic concept of purposeful availment. On the other hand, if he was advertising there, maybe we feel differently. Then there's the requirement that the lawsuit, quote, arise out of or relate to the defendant's contacts. We're going to return to this in a little bit. This is what makes claim specific or specific jurisdiction claim specific, because you're tying in some way the claim to what the defendant has done in the forum. It's what distinguishes general jurisdiction from specific jurisdiction. And then finally, there's a safety valve. It's been dormant in the Supreme Court, at least for a long time, but it's a backstop. And basically it says, even if the other requirements are satisfied, a state court cannot exercise personal jurisdiction if doing so would offend, quote, traditional notions of fair play and substantial justice. The gist here is that maybe there are certain situations where the courts just aren't going to rule out that they're going to step in and say, no, we're not letting a state exercise power here because for some reason it seems remarkably unfair. The Supreme Court, the key case is a case called Asahi Metal. I think it provides a good example of how and why this is rare. It's a 1987 decision, and basically a lawsuit was brought in California based on a car wreck. It turns out that one of the defendants involved sued another defendant saying, no, you're responsible. And both of those defendants, one was located in Taiwan and one was located in Japan. Well, the plaintiff settled, which means California had nothing more going on with the case. This was now a dispute between a Taiwanese manufacturer and a Japanese manufacturer based on their business dealings that had occurred in Taiwan. And so in that context, the court said, we think it's unfair to allow California to adjudicate this dispute. Again, that has been dormant for years. That was a 1987 case. The Supreme Court hasn't gone near that doctrine since. You should know it's out there. A good lawyer can deploy it, but it's not doing the work in the average jurisdictional case. Now, there are some recent cases tightening personal jurisdiction. They're important in their own right, but they're also going to set the stage for the most recent case. And one's a case called Walden v. Fiore. The takeaway is on the slide, but basically what happened is a police officer here in Georgia stopped a couple at the airport who were coming from Puerto Rico, and they seized a bag of cash. And the couple said, well, we're from Nevada, and this cash is legal, and so give us back our cash. And the police said, no, we think it's maybe drug money. We're going to keep it for now. And so the plaintiffs they went back to Nevada, to their home, and they filed suit. And they said, well, the police officer did reach out to Nevada because he knew that this would harm us in Nevada. We don't have our money in Nevada where we live. And the Supreme Court said, well, that's not personal availment really, because what we're talking about again is the defendant intentionally created contacts with the forum. And what that means is the contacts can't be just by virtue of the plaintiff somehow being connected to the forum. The defendant itself actually needs to reach out to the forum. So if the police officer had gone to Nevada and seized the bags himself there, well, that's purposeful availment, but grabbing them at Atlanta airport just because the plaintiffs are from Nevada is not. The next case speaks to that middle part, the part that I said makes a specific jurisdiction what it is. The idea that the claim is related to the contacts. It's a case called Bristol-Myers Squibb. The backstory, boiled down to its most essential, is that a whole bunch of plaintiffs said a specific pharmaceutical product called Plavix had injured them. The defendant was the manufacturer, Bristol-Myers Squibb, and the plaintiffs who sued in California weren't from California. They weren't injured in California, but they said, hey, Bristol-Myers Squibb, you sell this product in California. You're availing yourself of California's market, and our claim is related to that because we're complaining you're selling. And the Supreme Court said in that context, well, that's not enough. The claim neither arises out of the contacts with the forum because you didn't buy your pills in California, you didn't take them in California, nor is it related to because there's no California connection to this litigation, even if similar products are sold in California to other people. I left that open-ended intentionally because that's going to set up the case that was decided just last month. A lot of people looked at Bristol-Myers Squibb on the defense side. Next slide, please. And they said, well, based on what the court said, this must be a causal thing. We must be looking at whether the defendant's contacts with the forum caused the lawsuit. Because otherwise, they did sell the product in California in Bristol-Myers Squibb. And so they tried their hand, and they soon enough, a case came up that squarely presented the issue. It was against Ford Motor Company. And the court actually had before it whether specific jurisdiction requires a causal relationship. Ford Motor Company arose in Montana because a plaintiff was injured in Montana when her car allegedly malfunctioned in Montana. The plaintiff was from Montana, and so everything happened in Montana except for one thing. Ford sold this kind of car in Montana, but it didn't sell plaintiff her car in Montana. So Ford actually advertised, it serviced the vehicles, it had a market it was serving there, but plaintiff happened to get hers secondhand from somebody else in another state. And so you look at it, and it was perfect because it presents, well, did this, if causation is all that matters, then there should be no personal jurisdiction here because this plaintiff would have been injured no matter what Ford did in Montana. But if something looser is allowed, maybe, arguably, jurisdiction exists here. The Supreme Court ultimately sided with the plaintiffs on this one. They said that the case related to Ford's contacts with Montana because Ford was serving a market there and because every other event that happened relative to the case did happen in Montana. So it's bad news, obviously. That is the headline. We'll see where the court goes from there, but there's some takeaways because it's not all bad news with this case. First, the case shouldn't be a game changer. The Supreme Court said it was not changing anything else about its precedents. It was just saying we meant it when we said that relating to the contacts can be enough in some situations. And this just happened to be a really clear case because everything else happened in Montana. Second, the court said it was not deciding anything about the internet. That's actually the third time in recent years that the court has punted on personal jurisdiction on the internet questions. And so arguably somebody who's selling via the internet can say, I should be subject to better protection because I'm not physically doing anything in the forum. We'll see how that plays out over time. Third, the court said some things that could be affirmatively helpful to defendants. So while it was saying that arising out of and relating to are separate and that relating to can be enough, it was also saying that in this case, the clearest place where the suit belonged was in Montana and not in other states. And it said personal jurisdiction is largely about making a lawsuit, making sure it winds up where it belongs. And so as defendants, we can look at this later. And maybe if plaintiffs sue in a forum we like, we can say, well, no, in our case, the gravity of the contacts, the things that matter, they're happening somewhere else. And the Supreme Court has now told us that this should be a comparative endeavor. And so that can be turned to a defendant's advantage. And then finally, the court didn't cut back on the independent backstop of fair play and substantial justice. So that itself is noteworthy. So moving forward, defendants should be aware of the decision. While it is not on its face great news, it has things in it that can be used affirmatively and that skillful lawyers should be effectively deploying. That's the most recent word on courts from the Supreme Court about binding parties to litigation. I know that personal jurisdiction is a key component of also courts' investigatory power. And so I believe Brian Labbitt and Lanier may have some things to say about that as well.
Great, thank you. Thank you for summarizing a good 100 years of case law so succinctly. So far we've been talking about civil cases, right? For whether it's breach of contract or product liability, any type of civil type of claim. We haven't touched upon criminal related proceedings, and that's where the DOJ comes in. So we've seen, at least on the civil side, the U.S. Supreme Court on general jurisdiction limits it. Consent jurisdiction has become a hot topic, and we'll see where we go. Specific jurisdiction is another area where there's a lot of focus. Questionable whether Ford changed much or not, but that is to be determined. And now we come to the government. What if the government wants records? And the DOJ often does want records. So let me hand it over to Brian Labbitt, who will talk about the USA Patriot Act, as well as the recent development from the AML Act. Brian, you may be on mute. There we go.
One would think I would have figured that out at this point.
Somebody has to do it every call, I find. So.
You know, I
Thank
will.
you for
I
taking
will.
one for the team.
I will be the one. I apologize. Thank you, Lenny, and thank you to our hosts here at the CGCC. It's great to be with you today. I'm going to discuss today a development in the U.S. government's authority to subpoena records from foreign financial institutions that maintain what are known as correspondent banking accounts in the U.S. And Lanier is exactly right. I mean, to kind of orient this in terms of the discussion that we've been having today, much of which is kind of focused on U.S. courts' civil authority to reach out and bring defendants in front of them in civil cases. Personal jurisdiction also has a criminal component too. What I'm going to talk about today is the U.S. government's statutory authority to seek records from foreign financial institutions. But when the U.S. government goes to enforce those requests in U.S. court and seeks a court to reach out and compel a foreign financial institution to comply with a subpoena, personal jurisdiction issues come into play. So there is certainly an interrelated aspect with everything that my colleagues have been talking about today. But as I mentioned, I'm going to discuss today the U.S. government's authority to seek records from financial institutions that maintain what are known as correspondent accounts at U.S. financial institutions. As many of our friends on the webinar today who are with banks know, these accounts enable foreign financial institutions to conduct U.S. dollar denominated transactions for clients abroad. And it's significant because there is a large percentage of global commerce that is conducted using U.S. dollars or that implicates or touches the U.S. financial system in some way. And so it's often very important for foreign businesses and by extension their foreign banks to have access to these types of correspondent accounts. And this is particularly true where it's necessary to conduct, for example, a currency exchange as part of a transaction. Now, in recent years, correspondent accounts have become an increasingly important source of evidence for U.S. prosecutors pursuing financial crimes globally, particularly fraud, money laundering, corruption, and sanctions-related offenses. And a number of U.S. courts in the last several years have recognized that correspondent accounts can provide a basis for a potentially expansive scope of U.S. laws and, by extension, U.S. investigative authority to look into and obtain records and evidence related to potential violations of those laws. So looking here at our first slide, in cases where evidence may be located abroad, federal prosecutors really have a number of tools that they can use to obtain evidence that is abroad. I think one that many folks are familiar with is they can enlist the help of a foreign government in obtaining evidence under what's known as a mutual legal assistance treaty or agreement, or an MLAT. The U.S. has entered into MLATs with many countries globally, and it frequently turns to them to obtain evidence that may be located abroad. But another option, and one that I'm going to focus on a little bit today, is a subpoena issued pursuant to 31 U.S.C. 5318 K3A, which was first added to the U.S. Code as part of the Patriot Act in 2001. Now, Section 5318 has long authorized the U.S. government to subpoena any foreign bank that maintains a correspondent in the U.S. and request records related to such correspondent account, even if those records are maintained outside the United States. Now, notably, the statute includes, and if we can go to the next slide, please, the statute includes a limiting principle in the very text of the statute. Any records that are sought must be related to the correspondent account that the foreign bank maintains in the United States. Now, previously, foreign institutions that have received 5318 subpoenas have raised a number of arguments in response in seeking to excuse their compliance with the subpoena. For example, They've argued, as I was just alluding to, that the records sought were not related to their correspondent accounts within the United States. That's an argument that was open to them. That the U.S. lacked personal jurisdiction over the bank when the U.S. government went to enforce the subpoena. That the U.S. should first proceed via a mutual legal assistance treaty, or an MLAT, before resorting to a unilateral subpoena. And I was just discussing MLATs a few minutes ago. And finally, the comity principles precluded enforcement because, for example, a foreign law like a blocking statute or a privacy provision prohibited production except in accordance with an MLAT. Now, several years ago, a U.S. court, the D.C. Circuit, which is one of the leading courts here in the United States, considered a 5318 subpoena to a foreign financial institution, and it addressed a number of these defenses. And the court ultimately did enforce the subpoena and required production of the records sought, but it did leave open, I think, a number of questions relating to the scope and the enforceability of subpoenas under 5318. And I think there were some questions following the decision as to whether it would have come out differently if the facts were different. As the court noted in that case, and as I think it's been publicly reported in a number of different places, the Department of Justice has long sought revisions to 5318 that would seek to bolster their authority to seek foreign records from foreign financial institutions that are located outside the United States via subpoena. If we go to the next slide, please. So those efforts appear to have come to fruition earlier this year when the Anti-Money Laundering Act of 2020 was enacted. And Lanier discussed this a little bit at the outset of our webinar today. Specifically, the AMLA had a provision in its section 6308, which made a number of important amendments to section 5318, which is the subpoena provision I was just talking about. I think there are really two changes that are especially important to note. And the first is that the U.S. government may now seek any records relating to a correspondent account or any account at the foreign bank, including records maintained outside the United States, so long as those records are related to several enumerated categories, specifically any investigation of a violation of U.S. criminal law and several other categories. And as you can see, that's a fairly expansive list. It is not a difficult thing, particularly given the extraterritorial scope that's been recognized for U.S. criminal law in recent years, for U.S. prosecutors to make out a showing that a request is related to an investigation of a violation of U.S. criminal law. And while the bank may still move to quash the subpoena, Section 6308 amended the subpoena provision to provide that the sole basis for moving to quash, moving to prevent enforcement of the subpoena, can no longer be that compliance would conflict with a provision of a foreign secrecy or a confidentiality law. Now, as the slide here indicates, in addition to the broadened scope that I just mentioned, there are a number of other changes, most of them relating to enforcement. The U.S. government expressly now may seek to compel foreign financial institutions to comply with subpoenas through contempt proceedings brought in federal courts. And foreign banks that refuse to comply with subpoenas face statutory civil monetary penalties of up to $50,000 per day for non-compliance where they don't move to quash. And importantly, those penalties can be satisfied with funds taken directly from a correspondent account itself. So the U.S. government doesn't need to go over to a foreign country and domesticate its judgment and force it over there. It can simply seize funds that are located here in the United States in the correspondent account for non-compliance. And the U.S. government also has tools that it can use against the domestic banks that maintain those correspondent accounts. It can order those domestic banks to terminate a correspondent banking relationship with a foreign bank that fails to comply with the subpoena. And it can fine those banks $25,000 per day if they fail to comply with the termination order. So there are a number of very important changes in 6308 that really broaden the scope of the subpoenas that we're talking about. That the U.S. government may now seek to subpoena records relating to the correspondent account, which was, of course, the law before, but also any account at the foreign bank, even if it's not related to the foreign, to the correspondent account. So it's really a very significant extension of the U.S. government's subpoena power under 5318. I think it's important to note that this new provision has not been tested in court. It's only several months old. And if we go to the next slide, please. Thank you. I think it's important to note that this new provision really, it hasn't been tested yet. And it remains to be seen, I think, how the US government will use its new authorities and how US courts will interpret and enforce this provision. It's a fairly significant expansion of the US government's authority. And you'll often see the Department of Justice hesitant to use the full might of its power under a statute when it thinks that it might find itself in court having to litigate difficult issues. So I think we'll be watching closely how the US government uses its new authority and also how US courts interpret and enforce the provision. And I do think it's important to note that there are a number of potential defenses that may still remain available to a foreign bank that receives a subpoena under 5318. As I mentioned earlier, the statute itself, 6308 in the Anti-Money Laundering Act, attempted to close off a number of arguments, but I do think a number are still potentially open for foreign financial institutions. It would appear, for instance, that an institution may attempt to raise traditional subpoena defenses, such as arguing that the subpoena is overbroad, that it imposes an undue burden, or that it seeks privileged information. And I do think it could still argue, a foreign financial institution could still argue, the conflict with foreign secrecy or confidentiality laws are a factor that weigh against enforcement of the subpoena, while Section 6308 says that can't be the sole basis for quashing the subpoena. It appears to recognize that foreign financial institutions and banks can raise that defense along with others, including the ones that I just mentioned about overbreadth, privilege, and that sort of thing. I think it's also a fair question whether a bank could still argue that the US government should first pursue the requested information through a mutual legal assistance treaty. There is some legislative history surrounding the Anti-Money Laundering Act that could support that argument, although I think it's a little bit unclear how much weight a US court would give that legislative history, but it's still an argument that I think is potentially open to a foreign bank. And finally, and very relevant to what we've been talking about here today, I think a bank may also seek to raise arguments as to personal jurisdiction. And while there is case law, negative case law for foreign banks about personal jurisdiction with respect to records sought relating to correspondent accounts themselves, I think a foreign bank might have a plausible argument that even if it's consented to personal jurisdiction with respect to records relating to its correspondent accounts, other accounts, including those located outside the United States, may, depending on the facts, be beyond the reach of US courts. So I think that's something the courts are going to have to sort through in the years ahead as they confront subpoenas issued under the revised Section 5318. So just to kind of sum things up, I think Section 6308 significantly expands the US government's subpoena authority as it relates to foreign financial institutions that do maintain correspondent accounts in the US. And I think that's particularly true when this new provision is considered in light of some of the recent court decisions that I mentioned earlier that recognize a fairly expansive substantive scope of US criminal law. And I think it's important for foreign companies that use banks with correspondent accounts in the United States, which, to be clear, is probably most major banks. I think it's important for those companies to be aware of this provision and the scope of the US government's authority, at least under the statute, to seek records, even records unrelated to and beyond the correspondent accounts of the foreign bank. So we'll be closely watching how the US government uses this provision and how US courts enforce it going forward. Thanks, Lanier.
Great. Well, thank you so much for that. That was incredibly helpful. And again, you summarized a good 20 years of legislative and case law history. We have a question that came in, and it's related to this issue. And the question is, and I'll direct this to you, Brian Rabbit, see what you think. It says, or asks, what about the authority of a federal grand jury to issue a subpoena for a foreign bank's organization's head office account? So the hypothetical, I assume, is, let's say, a bank and the head office is in Beijing. Can the federal grand jury issue the subpoena to the New York branch and ask for documents located in Beijing?
So, Lanier, I mentioned earlier that there are several tools that U.S. prosecutors have to seek evidence located abroad. One of those is Mutual Legal Assistance Treaty. The other is the provision we were just talking about. There's also a third option that's open to the government. They're kind of colloquially known as Bank of Nova Scotia subpoenas. And what those essentially do is the government, usually acting through a grand jury, serves a subpoena on the U.S. branch of a foreign financial institution seeking compulsion, production of documents that are held abroad. And courts have enforced those subpoenas. Now, there are, of course, arguments against enforcement that any foreign financial institution could make, and whether it's enforceable will depend on all the facts and circumstances, but it's certainly a tool that the DOJ has used in the past and that courts have, in certain circumstances, enforced.
That's terrific. And those are, we talked about the traditional subpoena defenses, foreign secrecy is another defense, lack of personal jurisdiction is a defense. You can argue that they should go through the MLAT. So there are defenses you can raise. But Brian, let me ask you this question, and then we should wrap up because I see we're almost out of time. Is there a real home field advantage for the U.S. government in these cases? And if so, what's sort of the best way to try and level the playing field?
Well, I do think that the department is very familiar with the tools that it has, and U.S. courts are very comfortable. I think they've demonstrated that they're very comfortable both recognizing an expansive substantive scope of U.S. criminal law, as well as recognizing the authorities that DOJ has to investigate violations of those statutes. I do think U.S. courts are very fair, and I do think they will hold the Department of Justice to its proof, and they will be scrupulous in kind of how they look at these things. But it's certainly, and so there are arguments against enforcement that are potentially available to foreign banks, and I think U.S. courts will consider those in good faith, and I think that they'll put the U.S. government to its proof. But the U.S. government certainly has powerful tools at its disposal.
Well, that's certainly good to hear, and that's my experience too. I think whenever we've appeared for a foreign client, whether a bank or a company, I think the court has given the company or financial institution a fair shake, and when they go against the government, have required the government to come forward with some support for their arguments. A couple other things. We've been talking about correspondent banking in the context of the USA Patriot Act and the AML. But there's also a subpoenas in civil cases or document requests in civil cases for correspondent banking related documents. And Helen was slated to speak on that, and I apologize to Helen. I know who prepared diligently for this, and I'm sorry, but we're close to time. But in the slides, you will see Helen refers to a case, the Vasquez case. And for any financial institution which is trying to or arguing about the jurisdiction in a civil case with respect to a correspondent bank, or the jurisdictional hook relates to correspondent banking, that is a case to look at. I think Judge Engelmeyer in that decision really, there we go, thank you, Helen. It really did a nice job of passing through both the case law and the facts. And I think as a litigator and as representing banks, it is sometimes frustrating when a court doesn't fully understand how correspondent banking works. And I don't mean that pejoratively, it's a complicated subject and it's not intuitive. So I thought the Vasquez case that came out last year is a good decision. And so for any financial institutions out there that are currently dealing with correspondent banking in a civil case, that really is a useful case for us, for you to look at. We're at 3:04 now. I know we were meant to go for 1 hour. So if there are any questions, please ask now and we'll answer them. And then if not, you can feel free to reach out to any of us. One final question that has come in, and it's a question that says 6308 is an issue between the US and other governments. That is true. By taking companies as hostage, do you really think that the issue can be solved. The right way is for the US to negotiate with other governments. Well, look, I agree with you that the better way to seek documents in these situations is through the MLAT. Let me tell you what the government's response is. Right? We've seen this in other cases. The argument there by the US government is the MLAT procedure doesn't work. Right? That's what the government says, or it works badly. Again, I'm not saying endorsing that argument, but I'm saying that is what the government argues, that we try going through the MLAT procedure, whether it's in China or elsewhere, and we don't have any luck. And they have singled out China as being, again, according to the DOJ, the more difficult to get documents from. So what the US government will say in response to this question is, we've tried, and it hasn't worked. So now we need to do it unilaterally. My own view is the answer is probably a little bit more nuanced. While it's difficult to get the statistics, because a lot of these are, subpoenas issued confidentially, that at least when you look at the numbers under the Hague Convention, the Hague Evidence Convention, which is the procedure by which you can get evidence in a civil proceeding, China is right in the thick of it in terms of how many responses they, on a percentage basis, give when they get a Hague Convention request. So I think the answer is probably a little bit more nuanced than the US government said, but certainly the US government is well aware of this type of issue, and now you know their position. All right, I don't see any. I've got my little box says no open questions, so I think we have done it. I want to thank everybody for coming today. We have one announcement. Helen, can you pull up the last slide, please? Okay, so there we go. Thank you. Upcoming event, and I don't want to get in trouble with April and Hallie for missing this. So on May 13th, the CGCC has invited Mr. Richard Edelman, CEO of Edelman, which is a PR firm, to speak as part of its CGCC Leaders Roundtable event series. Mr. Edelman is the leader of one of the largest PR firms, and he will share his unique insights and experience on the changing rhetoric regarding the US-China business community and how to be a trustworthy employer leader. You can find the RSVP link in the chat box below, as well as on the website. So I want to thank the CGCC for hosting us and collaborating with us. I want to thank the panelists for doing a terrific job, really summarizing a lot of dense case law and statutes in a very, I thought, very, very effective way. And I want to thank all of you for taking, an hour and 8 minutes out of your busy days to hear us talk. So thank you very much, and we look forward to the next event.